Hi everyone, my name is Ramana Reddy and I'm a lawyer from Hyderabad. Today I wanted to talk to you about the basic process in an arbitration case end to end. I'm going to try to simplify this as much as possible. Some of you may already know some of this, so please bear with me for the people who don't know some of this. But in this video, I want to talk to you about the end to end process at a high level as to what is the procedure for an arbitration case. So before we get to what is the procedure, let's try to understand what is arbitration. Arbitration is basically an alternative dispute resolution mechanism. So what that basically means is, the courts are overburdened with cases, and the courts are looking for ways to, for alternate ways through which people can resolve their disputes. And arbitration is one popular way to do it. So what basically happens is, let's say that I am a partner in a partnership with let's say with one other partner, and we agree in advance, in the partnership deed that should any dispute arise, then this dispute will not go to court. It will go to an arbitrator, to a sole arbitrator who is mutually, who's appointed by mutual consent. That is, if I agree, he agrees for someone to be the arbitrator. That arbitrator will resolve disputes. Now, in most cases, obviously, I'm going to pick my arbitrator, and he's not going to agree with my arbitrator because he's going to feel that my arbitrator is going to be biased in my favor. And the same goes with me too. So what happens is, so the first step, generally speaking, a lot depends on your facts and circumstances, but generally speaking, what happens is, the first step is if I have a dispute with my partner, say for example, that there is 5 CR sitting in our partnership account, and the other partner has somehow cheated me, or there's money from customers that he has appropriated for himself, and I want to invoke arbitration against my other partner. What I do is I issue a notice invoking arbitration. So I issue a notice saying, look, there are disputes between us. I nominate Mr. A to be the arbitrator to resolve the disputes between us. Now, most likely he's not going to agree to Mr. A being the arbitrator. So he may nominate his own arbitrator, Mr. Arbitrator B. And now we cannot agree on a sole arbitrator. So what do we do now? So in this case, most likely what happens, I think happens with a lot of cases, is when parties cannot agree on an arbitrator, is that they go to the High Court under Section 11 of the Arbitration Act for appointment of the arbitrator, for appointment of an arbitrator. Now, you may be thinking, well, Ramana, you just said the whole point of arbitration is that we get to skip the courts. Well, you can skip the courts, but not entirely, because somebody has to appoint an arbitrator. If you guys cannot do it yourself, then you have to go to a court, and the court will appoint an arbitrator. And, the arbitrator will then run the arbitration proceedings. So once an arbitrator is appointed, then me and my partner, both of us go before the arbitrator, and we put forth our disputes before the arbitrator, and the arbitrator will resolve the disputes. And we'll get to the procedure as to what happens once the arbitrator is appointed. But I want to talk to you about one special circumstance that happens before appointment of an arbitrator, or maybe even before you issue the notice invoking arbitration. So let's say, for example, that, take the same partnership dispute. There is, say, 5 crores sitting in a bank account. It has come to my knowledge that my partner is trying to withdraw that money and run away. And what do I do? Well, then I have to file something called a Section 9 before the civil court, not before the High Court, before the civil court. And I say, look, the very thing that I'm fighting for, the 5 crores, the assets of the partnership, they themselves may disappear by the time an arbitrator is appointed. Because if this man withdraws the 5 crores and he runs away, what am I going to be left with? So I will file an application under Section 9 for interim relief before the civil court, saying, in this situation probably I would ask for a direction from the court to the bank, telling them to freeze the account, or to prevent either of the partners from withdrawing money more than than what is required for day-to-day operations, and so on and so forth. So the Section 9 is there just to protect whatever is in dispute. So let's say I have the Section 9 order now. I have that protection that nobody can withdraw that money. Then I issue a notice invoking arbitration, and I appoint Mr. A, he doesn't agree, he replies with Mr. B, I don't agree. Both of us go to the High Court and an arbitrator is finally appointed. So now what happens is now the arbitrator will call the both of us. He will issue notices to both of us saying, look, I have been appointed by the High Court to adjudicate the disputes between you guys. So why don't you, so both of you come, and meet me in person or virtually, and we can fix up a calendar. Now the procedure once this stage happens, once an arbitrator is appointed, the procedure more or less is, follows the procedure that is laid down under the Civil Procedure Code. So let's going back to my partnership agreement or my partnership dispute. Let's say I am saying that my partner has taken money from customers and kept it for himself and he's not giving me any of the money. So I will be the claimant, right? I will be the plaintiff because I'm the one who's making the claim against him. So I will be the claimant and I will file something called a statement of claim, and and then he will have the opportunity to file his defense, which is the statement of defense. And once I go through his contents, it depends on if he brings up some new aspects of of the case, or if I want to respond to the defense, then I will file something called a rejoinder or a reply to the statement of defense. And once the pleadings are closed, then now that the arbitrator has all the material before him, at least all the written material, so my statement of claim along with all the documents that I want to file in my support, the statement of defense, with all the documents that he wants to file in his support, and my reply. Now he has all, at least all the pleadings, that's what they're called. At least all the written record is kind of final. Now at this stage, the arbitrator frames issues. So the arbitrator, makes a list of 5 to 10 or 15 or whatever, list of questions that the arbitrator has to finally answer, because the answers are only as good as the quality of questions. If you are asking good questions, you will probably get good answers. So in a civil trial, which is basically what an arbitration is, they frame issues to determine, okay, so what are we trying to decide here? It could be, so if in this particular case, if my allegation is the partner has taken money from customers and he's not repaying, and he's not putting it in the partnership, and the question would be, has the partner collected money from Mr. X and not deposited into this, into the partnership account, and so on and so forth. These kind of questions will be framed to get to the truth of the issue. Thereafter, once the pleadings are complete, then I, as the claimant, I field my witness. And I say, because it is not just enough to say, look, he owes me money. Okay, that's fine. But really the heart of a civil trial is evidence, which basically means that I will field my best witness, which could just be me. So I will say, okay, I am willing to be cross-examined. The defense counsel, or the other partner, who's the defendant's counsel's lawyer, is free to ask me any question he wants on the basis of my statement of claim, on the basis of my rejoinder. He's free to ask me any question that he wants, and I'm basically opening myself up for review. And to do that, I will have to file something called a chief affidavit, which is basically my statement of evidence. It's usually just I don't have to say this word, but it's usually just a rehash of the statement of claim. And so I file my statement of evidence, provided, but if there's something new, if there's some technical aspect that you want to dwell on, and you may want to call, say, like your IT guy for some particular aspect of the case. For him, the chief affidavit will be slightly different, but whatever. But it will contain basically your statement of evidence. And the other side is going to grill you, or in my case, is going to grill me on the contents of the statement of claim that I've filed, or the documents that I've filed, to basically show that, look, the other partner has not really taken any money from customers, that he's not contributed to the partnership, and so on. And basically your claims that they are just BS. And that is what he's going to. He's going to try to poke holes in my case. So that is for the plaintiff evidence is concerned. Once my evidence is closed, then the defendant opens himself up for cross-examination. I mean, so the other partner will file his statement, he'll file his chief affidavit, through which I will have the opportunity to cross-examine. And, we poke holes in each other's cases. Just, this is just the process to get to the truth, because you have to open yourself up to the other person if you're making claims against them. After this, arguments happen, and then the arbitral award is passed. And that is basically one full cycle. Now, there's obviously procedure after this also. Let's say, for example, that I lose in the arbitration, I can file an appeal under Section 34, questioning that, that arbitral award. But now, the legislature or the, or basically, the parliament or the government, they've made it very difficult for somebody to question an arbitral award, because otherwise it was just becoming like just a very routine practice, and that sanctity for arbitral awards was just not there. So, I'm not going to talk about the appeal provisions now, but I think from beginning to end, so your beginning could either be a Section 9 to protect really, say the money in your bank account, or to protect the thing that you're fighting for. Or if there's no such urgency, it could just be a notice invoking arbitration, appointing Mr. A as the arbitrator. So that could, depending on your circumstance, be the first step in the arbitration or in invoking arbitration, to which you may have to go to, you may have to travel to the High Court to appoint an arbitrator, and thereafter, come to the arbitrator and then have all your claims filed, and then have your arbitral award. So to summarize, the arbitration is an alternative dispute resolution mechanism, and it is basically a civil trial which either starts off with a Section 9 or either starts off with a notice invoking arbitration, and it ends with an arbitral award. It travels, it goes to the High Court under Section 11(8). Then thereafter comes to the arbitrator. There's a statement of claim, there's a statement of defense, there's rejoinders. Then there's evidence that is led by both parties. Both parties open themselves up for cross-examination, and then there's an arbitral award that is passed. So basically, that is the whole arbitration process. I hope that was helpful. Thank you for watching.